Hello friends, let's discuss about the important topic of polity, emergency provisions. The Constitution envisages three types of emergencies. Article 352, emergency arising from threat to security of the nation or a part thereof. Article 356, breakdown of constitutional machinery in a state. And financial emergency, that is Article 360. Let's discuss about the Article 352. Grounds. President on his satisfaction proclaim emergency on the whole of India or part thereof can declare proclaim emergency on grounds of war, external aggression, armed rebellion. A proclamation can be made before the actual occurrence of war, external aggression, or armed rebellion. Constitution 38th Amendment allows President to issue more than one proclamation at the same time. Before 44th Amendment, emergency could be declared on grounds of war, external aggression, and internal disturbance. But the Constitution 44th Amendment substituted internal disturbance with armed rebellion. Role of Cabinet. President can issue proclamation of emergency or its revocation only if Union Cabinet including Prime Minister has communicated to the President of such intention in writing, and b. Thus the decision has to be taken collectively by the Union Cabinet. Approval. The proclamation needs to be approved by both houses of Parliament within 1 month. Thus the proclamation, if not approved by both houses of Parliament within 1 month, shall cease to operate. Prior to 44th Amendment, the time required for approval by both houses of Parliament was 2 months. Constitution 44th Amendment reduced it to 1 month. The proclamation approving emergency has to be passed by each house by a total membership of each house and not less than 2/3 of the majority of membership present and voting in each house. Prior to 44th Amendment, proclamation was passed by a simple majority in both houses of Parliament. Tenure. Once approved by Parliament, the proclamation remains in force for 6 months, unless it is revoked earlier. For Constitution, for continuation of emergency beyond 6 months, the proclamation needs to be approved again by both houses of the Parliament. Revocation. It has to be revoked by President once Lok Sabha passes its revocation by simple majority of the members of the House present and voting. If 1/10 of the total members of Lok Sabha has given in writing their intention to revoke proclamation of emergency to the Speaker in writing if the session is in session, to the President if the House is not in session, or a special sitting of the House shall be convened within 14 days. Effect. Parliament becomes empowered to make laws within respect to any matter enumerated in state list under Schedule 7. Article 19 remains suspended. Right to move court under Part 3 of Indian Constitution shall remain suspended except Article 20 and 21. Parliament can extend the life of Lok Sabha beyond its normal period of 5 years by 1 year each time, subject to a maximum period of 6 months after the proclamation has ceased to operate. Now, let's discuss about another emergency, that is Article 356, that is failure of constitutional machinery in state. Grounds. If the President on receipt of report from Governor of a state or otherwise is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with constitutional provisions, the President may assume to himself a. All or any of the functions of the government of the state, b. All or any of the powers vested in or exercisable by the governor, c. Declare that the powers of the state legislature are to be exercised by the Parliament. President may even suspend in whole or in part of the provision of the Constitution relating to anybody or authority in the state. President cannot assume to himself powers of High Court approval. Every such proclamation shall be laid before each House of Parliament. Such proclamation needs to be approved within 2 months by each House of Parliament by simple majority. Tenure. The proclamation, once approved, shall be in force for a period of 6 months. The life of proclamation can be extended for further 6 months if both houses approves its continuance by passing it. Maximum time for such proclamation remains in force is for 3 years. Discuss about Constitution 44th Amendment with respect to Article 356. As per 44th Amendment, the following conditions must be fulfilled for the proclamation to be carried beyond 1 year. Proclamation for emergency under Article 352 must be in operation in the whole of India or the concerned state or in part of the state. Election Commission certifies that the continuation in force of proclamation under Article 356 is necessary on account of holding elections to the concerned legislative assembly. Its effect: state legislature ceases to function as it is either dissolved or is kept in suspended animation. Now, the discuss about financial emergency, that is Article 360. Grounds of Article 360. If the President is satisfied that financial stability or credit of India or any part thereof is threatened, he may by proclamation under Article 360 make a declaration. A proclamation under Article 360 can be revoked by a subsequent proclamation. Approval. Such proclamation A. shall be laid before each House of Parliament. B. shall cease to operate at the expiration of 2 months unless before the expiration of that period it has been approved by resolution of both Houses of Parliament by simple majority. Reduction of salaries and allowance of government employees is the effect of Article 360. Another effect is all money bills, finance bills, or other bills involving expenditure from state consolidated funds shall be reserved for consent of the President after being passed by state legislature. Let's discuss about a major differences between martial law and national emergency. Martial law affects only fundamental rights, and national emergency affects not only fundamental rights but also center-state relations, distribution of the revenues, and legislative powers between center and states, and may extend the tenure of the parliament. Martial law suspends the government and ordinary law courts, but the national emergency position of the government and ordinary law courts is unaffected. In martial law, it is imposed to restore the breakdown of law and order due to any reason, but in case of national emergency, it can be imposed only on 3 grounds: war, external aggression, or armed rebellion. In case of martial law, it is imposed in some specific area of the country, but in case of national emergency, it is imposed either in the whole country or in any part of it. In case of martial law, it has no specific provision in the constitution, it is implicit, but in case of national emergency, it has specific and detailed provision in the constitution, it is explicit. So friends, this was the brief about the emergencies in India. Thank you very much.